cow. Thank you. Appreciate you letting me know that. I forgot to unmute the mic. Anyways, what I was saying is we are now caught up, so we're going to be watching live this case. Finally, way ahead of schedule. I thought it was going to be middle of the afternoon session. So let's jump in the courtroom and start watching.
Approaches you or does anything, let me know. And I also
So it looks like they're having some sort of discussion about a juror getting approached. It sounded like so interesting. But as I was saying while I was muted, I was sharing that I'm going to be doing some Murdoch hearing coverage later because that hearing I've been monitoring it as well, and man, there's some pretty big things coming out of it that are quite interesting. Looks like he might get a new trial, so that'll be an interesting situation. Don't know what's going on here though. Appears the camera's at the light. Something must have happened with a juror, it sounded like. So I don't know. Interesting. So we'll come back to the courtroom in a minute. But yeah, this case so far, I mean, everything I've seen, I have not seen the goods here yet from the state. I'm a little disappointed in exactly what it is they're trying to prove, with her. Now, her husband is the gun owner, so I feel like there's more connection there with him because of him being the owner of the gun and being able to say, hey, he should have been aware of where his guns were. He should have had them locked up. But she's not a gun owner. I mean, only you. And the thing is, we can say, well, she could have done this, and it could have been out. They got to prove she knew the gun was out. Number one, that he had access to it, and that she didn't believe her husband was securing it. The messages they've put up, it was clear she was shooting a 9mm for the first time, and she's acting like somebody who's not very, clearly not involved with weapons on a daily basis. She's more involved with horses. And then the idea that, hey, you can look at those messages, and that's what the defense attorney's saying. You look at those messages in a vacuum with a school shooting background to it, and you go, oh my God, you should have known. You look at it from a standpoint of raising a teenager, and he's trying to get out of cleaning his room, and he's claiming clothes are coming out. I mean, do you race him to a doctor because he wants to get out of cleaning his room? I mean, they're trying to deal with things the best they can. I mean, a lot of parents are sometimes, not running right over to the doctor's office. It takes a lot. Now, the question is, the issue that I have with this is, what is the standard that the state of Michigan is saying is, how much is too much? In other words, what's the definable standard here that they're going to say? Because the involuntary manslaughter law they're charged under doesn't define that standard. In fact, it doesn't even really cover this. That's why there was an appeal, because it requires a causal link. In other words, it requires to be certain that something she did directly goes in and causes the death. And with the intervention of her son choosing to do this, that created a problem, and that was why this ended up at the Supreme Court or Court of Appeals in Michigan. They found that there was evidence to potentially suggest that a jury could make that finding, but the issue that I didn't see them making was potentially a due process issue, and the due process issue says, hey, every person's entitled to the due process of law. In other words, they're entitled to, and under the procedural, something called procedural due process, it requires that you have a defined standard when you're trying to prosecute somebody, or you're trying to sue somebody, or you're trying to hold somebody accountable. And meaning, you've got to be able to show what's the definable standard. And in this case, what's the definable standard? I mean, if their theory of the case if they can't put a causal link to her knowing and having knowledge of the firearm being available, then what is the link in saying what is the level of intervention that a parent should have? What's the standard? How do you define that standard? And since there's not a definable standard in the manslaughter statute, it shouldn't have been allowed to be prosecuted due to due process issues. Now, if the state legislature wants to go put a law in effect and define those standards, then they can do that and they can use the normal procedures. But I don't think this law that's on the books right now, and I assume the defense attorney is going to try to make an argument of some sort to that. But it's also something that if the jury were to choose to convict and the theory of the prosecution becomes clear of what they argue in their closing, it opens up on appeal for this to get it reversed. So I think the defense attorney's obviously trying to win the case here, but I think they're also wanting to say, okay, let's see what the theory of the case is. Anyways, looks like they're back. Let's jump into the courtroom.
I would love it. I don't know if I'm allowed to ask you to do that, though. Am I allowed to ask you to do that? I'm still maintaining a public courtroom, so I think I am. Thank you. Thank you. So you're off, right? This will take just a second. Thank you. I just wanted to ask you.
So it looks like we're getting kicked out, I guess. So yeah, I don't know what's going on here. A juror must have been approached, it appears, and I guess that's why we're not able to hear what's going on with this. But and I guess the judge felt like this is still a public courtroom. She's not closing the courtroom, so therefore the cameras can go. And that is true. They shouldn't have turned the cameras off. They don't have an obligation to turn the cameras off. I wonder if another camera. I know Law and Crime has different cameras going. Let me see if they're up. All right, so it looks like they're all on the same feed we are. They were on different feeds. There was a Zoom feed that was not as high quality. But anyways, I'm going to show this. Let's see here, jury instructions. All right, so what I'm showing here right now, this is the hold on here. Let me get the jury instructions that for Michigan for let's see here, for I'm going to pull them up for the involuntary manslaughter. Find the homicide here. There it is. So we start here with the general instructions. So these are the instructions. This is essentially what the state has to prove. And you can see here first that the defendant caused the death and that this is and died as a result of whatever alleged act it was. So in this case, it would be either her failure to act when pulling her son out, knowledge, potential knowledge. It would be gross negligence in this instance. Second, in doing the act that caused blank's death, the defendant acted in a gross negligent manner. So the definable act, which is what we're waiting for here, what's the definable act? Was it she ignored a gun being out that they could say she knew of this? Was it And I believe what they're hinging it on is she went to the school. She chose to not take him out, even with a picture and a drawing of a weapon that looks similar to a weapon he had just bought. She didn't run home. She didn't double check. She didn't pull him out. She went back to work. And they're saying that rose to the level of negligence. And then third, that the defendant caused the death without lawful excuse or justification. So now you're going to go to the negligence here. And let's see here. And the definition of gross negligence means more than carelessness. It means willful disregarding the results to others that might follow from an act or failure. In order to find that the defendant was grossly negligent, you must find each of the following three things: that the defendant knew of the danger to another, knew there was a situation that required him or her to take ordinary care to avoid injuring another. Second, that the defendant could have avoided injuring another by using ordinary care. And third, that the defendant failed to use ordinary care to prevent injuring another, when to a reasonable person it must have been apparent that the result would likely lead to serious injury. So the issue here is the school officials didn't see the potential injury because they didn't throw him out of the school. They didn't expel him. They didn't suspend him for the day. They didn't say, ma'am, he's suspended for the day. Take him to get help. We'll address this in the morning. They let him go back. So why would you then think that she would have thought that there was a likelihood of injury? If she didn't believe there was a likelihood of injury or death or a school shooting happening, and she let him stay in school, she's not guilty if that's the issue they're going to do, or if that's the issue they're going to rise. And then, of course, obviously, if they can prove that she somehow knew he had access to the gun and didn't take steps to avoid that, well, that would also be something. But at this point, I haven't heard anything that she directly was responsible for the gun or knew anything with it. Anyways, they're back in. Let's get back to court here. All right, we're running this at. All right, so we are back now.
Yes. And you are still on. Okay.
Understand.
Okay. You can be seated. Go ahead, Pastor.
Thank you. Okay. Mr. Hopkins, when we broke for lunch, we were talking about the phone conversation you had with Jennifer Crumbley when you called her in.
And yes, the school did know that because they knew he was at the gun range. So,
They did. Okay. Do you recall approximately what time?
They knew because remember, you heard the talk in the emails or in the voicemail where they were referencing the fact they'd been to the gun range. He just gotten a gun as a present. And that's how they were kind of justifying why he was looking up the ammo. Remember, they had him looking ammo up in school the day before.
So when I was notified that they were there, I had actually texted Mr. Ejak to please come back to my office. He had been present through a majority of the meeting until we confirmed the parents were arriving, and then asked him to return. I then went out to the lobby of the counseling office area to greet the parents.
Okay. So from the phone call where you actually spoke with Jennifer Crumbley was 9:27 a.m. From that point, 9:27 a.m. until 10:40 a.m., where was the defendant's son?
In my office.
Okay. And what was going on there?
There was a conversation between myself, the defendant's son, and Mr. Ejak was there as well until approximately 10 a.m. During that time, I was still trying to affirm that parents would be able to arrive, and I was talking with the student about really what I was going to be sharing with his parents.
Okay. And tell me, sir, what was your expectation of the result of that meeting that you called?
My hope was that they would set a plan to get help for their son.
Okay. Was your expectation that they would take their son home?
That was my hope.
Your hope. Okay. So at 10:40 a.m., you welcome them into your office. Tell me what happens next.
We walked back into my office. The student was in
This is actually the key right here. This is the key testimony to listen to.
Sat down
we're going to see the first
three seats
link
in my
here
office,
of how she's involved.
2 directly across from me, and then one that was kind of off the corner of my desk a little more. The student was in one of the 2 across from me. Dad sat in one of those, and Mom sat in the one that was more at a diagonal from where I was.
When the defendant and her husband walked into the office, did they approach their son?
Not to my memory, no.
Okay. Did either one of them hug their son?
No.
So who started the meeting?
I believe I did, and I went over some of the things that I had talked through over the past 2 days with their son. I wanted to confirm some things I wasn't sure of, so I confirmed with Mom that she did receive a voicemail from Miss Fine the day before, and just confirmed that what was stated in that meeting was true. And Mom confirmed that she received it and that that was true. And then I went over some of the things that I had received messages of from the teachers over the past 2 days.
Okay. Now, when you were asking Jennifer Crumbley to confirm that information, was she sharing any additional information with you?
Not to my memory, no.
Now, describe Jennifer Crumbley's demeanor when she walked into your office.
She sat down in the chair, felt a little bit distant.
What do you mean by that?
More just kind of like, it felt like it was a little bit of an inconvenience to be there.
Okay, you testified that you had to have these meetings in the past.
Yes.
Was this meeting similar to those meetings, or was it different?
Your Honor, objection to relevance.
Judge, it's relevant because the crux of this case is the defendant's failure to use ordinary care to avoid a tragedy, and her failure to use just ordinary care contributed to her failure to adhere to her parental responsibilities, which is her duty under Michigan law. It's also her approach and
You're hearing that. There it is.
Was the meeting unusual in any way? How many meetings like this?
See, this is it. We just read this. It's great that this testimony happened.
Okay, so, I mean, people react differently to, no one's very excited about coming to this school about their child, right?
I would agree.
But this wasn't a discipline.
Issue with that sentiment, though, is whether she had the knowledge. And right now, I haven't heard that she knew the gun wasn't improperly stored. And if she believed the gun lock was on it, under the laws of Michigan, that was a properly stored gun. So they have to prove, without calling James, they will never know that. So this is the whole
James Crumbley was
deal here.
next to him. Jennifer Crumbley was off to your side.
I don't remember which chair student and dad were in.
That's
I know
fine.
they were both across from me, and Jennifer Crumbley was off to the side a little
Okay.
more.
So you were asking them to confirm the voicemail, information left in the voicemail November 29th.
And what they're going to say is that that document or the math worksheet is what should have cued her into the potential for a school shooting, because that's obviously what he was talking about doing. Her failure to remove him, as you're hearing there, is causing ordinary negligence. That she didn't,
Did you tell
or at least the definition of ordinary negligence, and that's what they have to reach in this case.
his own?
So this witness is the star.
I did mention that, yes.
Okay, what else did you mention?
I mentioned the conversations I had with the student of the friend leaving, that the student was sad about that, the dog, family dog passing, the grandparent, COVID being hard, and all of those, which were told to me by the student, were also confirmed by the
Okay.
parents.
Now, when you say confirmed, I take it that, I don't want to put words in your mouth, but this didn't catch Jennifer Crumbley by surprise.
It did not feel as though it was new information to the parents.
All right. Now, you testified that it was your hope that they would take him home that day. What do you mean by that?
I wanted to make sure the student was able to get the support that I felt was needed, and I was wanting it to be as soon as possible.
Okay. Did you feel like that he could be left alone at that point?
I did not want him left alone at that point. In fact, that's why I kept him in my office until I could make contact with the parents.
Okay. And you communicated that to the defendant?
I do not remember.
So then why would you allow him to then go
So,
back
did you,
into
discuss-
class?
Well, first of all, did you communicate
if
your
that's how
hope?
strong you felt about him not being
Yes,
left alone?
my words were, I want him to be seen as soon as possible, today if possible, and I actually provided a list of mental health resources and handed that to Mom.
Now, when you say a list of mental health resources, could you explain a little bit more what that means?
Yeah, it was multiple pages of different.
I mean, a school official, I know from dealing with my kid's school, if they want your kid out of the school, or at least if they want something done with your child, they're gonna do it. You don't have a right
And
to.
that was actually provided to the defendant and her husband?
I handed it to Mom.
Okay. Now, when you communicated your expectation, what was Jennifer Crumbley's response?
I didn't feel as if it was going to be an absolute no, but it was made quite clear that it wasn't possible to do it that day.
Why do you say it was made clear it wasn't possible to do it
That
that day?
they had to return to work and they were unable to do it that day.
Well, who said that?
Mom,
Mom, is it Jennifer Crumbley?
yes.
Did she speak for James, or did James speak as well?
I don't remember James speaking on that topic.
So what happened next?
My comment was, then I said I'd like to see him as soon as possible. Today is possible. I was told today is not possible, so I said, is 48 hours possible? I will be following up.
In those dozens of meetings in the past, had anyone ever said that they couldn't have their son go with them that day?
I had not had that happen in a situation.
Never, I would object to the relevance.
It's the same response as last objection.
Okay, well, I guess you want to back up even further. Have you ever asked parents to take their child home with them that day? Have you ever requested that before?
I've encouraged parents to be able to get their son and or daughter help and therapy. I had never had it where it was feeling like I needed to push to make it happen.
And you say the feeling like you needed to push to make it happen. That's what you're experiencing November the 30th, 2021.
That is correct.
Okay. So tell me what's going on through your mind at this point.
I was a little caught off guard and a little confused because it was
And not to say I don't believe this guy, but I feel like this is a lot of Monday morning quarterbacking going on by him.
Parents came, and in fact, both parents came, which I wasn't expecting, nor did I request. I was a little surprised at their willingness to come, but then not completely follow through.
Okay. Now, you told the defendant and her husband that your opinion was this drawing showed suicidal ideation. Is that right?
That was my opinion, and I did not. I saw it as somebody who was showing signs that could be associated with suicide, and so I took that and out of. Just
So you didn't see it as a school shooting. That's telling right there.
Okay.
There it
You
is.
communicated that to the
In-
defendant.
I did.
Did you specifically ask them to take him home that day?
I did not specifically ask them to take him home.
Boom.
I asked them to take him to get help and therapeutic help.
Now, when it was made clear to you that Jennifer Crumbley was not going to take her son home, and neither was James, what is your next step?
My next step was to try and think of what is best for the student in front of me in this moment.
Okay. And
If the jury understands the law, and we just saw the jury instruction they're going to be given. So, I mean,
So my first thought was, I don't want him alone. I want to make sure somebody who's experiencing.
why didn't you want him alone?
Because I don't want a student who may be suicidal alone.
Okay. I cut you off. Please continue.
I then, after determining I didn't want him alone, I went through different options of what needed to happen. At that point, the student had requested to be able to stay in class, and parents were on board with him staying in class as a good placement. I was with our dean, who would be the person who does discipline, and of the 4 adults in the room, I'm the one who can't remove a student from class. So I asked our dean if there was any reason from a discipline standpoint or anything that he needed to do from a discipline standpoint that would prevent the student from returning to class.
And the response there?
No.
So, you told us that you were taken aback. You were a bit confused by the response of the defendant. And now you moved on to your next decision with the information in front of you. Is that when you turned to Mr. Ejak and requested information regarding discipline?
It is.
Okay. And how did the meeting end? Tell us about that.
The meeting at that point ended fairly abruptly.
What do you mean by that?
Well, at that point, we had a student wanting to return to class. I knew that he wasn't going to be able to be removed to go get therapy that day. So I was kind of left with an option of, okay, this student, I can't keep a student from class if there isn't a reason to keep him from class. I asked if there was a discipline reason, and once we had kind of gotten to that point, I allowed the student to go back to class based on the information I had, and then Mom asked if we were done. At
Those
that
were her
point.
words. Are we done?
Yeah,
Okay.
yes.
What was your response to that?
My response was, I guess so.
Now, you let her son go back to class before James and Jennifer left your office. Is that right?
There was a short time overlap of maybe 1 minute.
So tell us what happened when it was communicated to the defendant's son that he could go back to class and he left. What happened in that time span?
There wasn't anything noteworthy or different than any other student I've had leave my office. I wrote a pass to allow him back into the classroom, And he had his belongings and went to class.
When he left, did either James or Jennifer hug him?
Not to my memory, no.
Did they say anything to him?
Not to my memory.
Did you say anything to him?
I did.
What did you say?
When I handed him his pass, I just let him know that I cared about him.
And why did you say that?
Because I do. Like, I did. It was an hour and a half with a student who is sad, with a student that we were talking about future plans.
Now, in the time span from when
That's
showed him a pass and
exactly.
back to
And
class,
in my son's school,
Jennifer was there,
I mean,
continued
if
discussion without
they had a situation where they found a drawing of a gun and were getting a notification. They had the police at the store or at the school, and this was not so long ago when this happened that those things weren't still happening. So this school, part of what's happening in this instance here is the school officials are slightly covering up, I think, their own inactions.
My plan as far as follow-up.
But clearly nobody thought, and again, that's the key here. They have to have thought that
Discussions and more plans about getting help.
a school shooting would happen. And clearly this guy didn't, because him drawing that on a math sheet should have got him suspended from school. That would have forced the parents to take action and then readdress this. I mean, that's the best way to force things to happen.
Again, was that typical
But
or atypical?
clearly he's thinking it's a suicidal
Same response.
outreach or cry for help. He's not thinking it's a school shooting. His parents aren't thinking it's a school shooting.
Parents came, got their kids, and it was fine.
So to be sitting here wanting to lock the parents up
In my office.
because they didn't hug their kid, they didn't do this or do that. Again, where is the standard? What's the standard that a parent must provide? Because you cannot have what's going on in this case where a prosecutor just decides, well, there wasn't a hug. This situation, every parent should hug their child walking out of the school. And if you don't, and your child goes and harms somebody, now you're in court being charged for their actions. That's crazy.
When I'm asking questions today, if I ask anything confusing, can you please?
All right, so this is going to be very important here.
Thank you, I appreciate that. It's true that you are licensed as a school counselor, correct?
That is correct.
What does it mean to be licensed as a school counselor, or what does one have to do to obtain a license?
You have to graduate with a degree from an accredited university and meet all of the standards of the state of Michigan to become a school counselor.
And obviously you did that.
Yes.
Can you give us some examples of the standards?
I have to meet the required trainings based on hours over a certain period of years.
Do you recall how many hours or?
Well, they're broken up into specific categories, but in totality, it's on top of the degree, 150 hours every 5 years.
150 every 5 years, and you just mentioned that they're broken up into categories. Can you just give us a quick idea of what these categories are?
Yep, some are based on college. They have to be hours specific towards helping students get to college. Some are based on careers, and some are more general.
Are any of those based on suicide prevention or danger at school or discipline?
Those hours are not, but a degree in counseling is.
Aside from receiving your degree and those 150 hours of training, or hours that you had to obtain your license, did you have any other additional training or continuing type education regarding becoming a counselor?
Yes.
Okay, tell us about that.
The training is continual and goes well above and beyond 150 hours. It's oftentimes based on school need and oftentimes based on what is important in the profession.
And when you were testifying, did you say you graduated in 2012?
No.
I'm sorry, 2009?
I graduated undergrad in 2009, master's in 2015.
I'm sorry, okay, master's in 15, and at what point did you become licensed? Were you licensed, what year?
I passed the school counseling exam in the summer of 2014.
Okay, so starting in summer of 2014, you had to do at least 150 hours every 5-year period, correct?
When I was hired in 2015 and had the full licensure, I did 5 years, renewed my license in 2020.
Did you do the 150 hours or did you do more hours?
More.
How, can you give us an idea of how many hours?
Significantly more.
Okay, when you say significantly more, are you talking double the number of hours, 50 extra hours?
I wouldn't keep track of all the hours that far beyond, but significantly more.
Okay, I understand, I just don't know.
More than 200.
More than 200, okay. And then, again, you've continued since that time when you renewed your license in 2020 to keep getting more and more hours, correct?
Correct.
So by 2021, it's fair to say you had over the 150 hours you needed, the additional hours you talked about, and then you had already started moving on into the 150 you would need for renewing your license for the next 5 years.
Yes.
Okay, did I say all that right?
I believe so.
Okay, thank you. Now, when, I want to go back through the exhibits that Mr. Keast admitted while you were on the stand, and if you need to see any of the exhibits, please let me know. I'm going to start with 155, which were the emails that started off with Ms. Is it DeRiker?
It is DeRiker.
DeRiker. Do you need to see that in order to?
I would like to see that.
Okay,
Yes, please.
Your Honor, may I put it up on the screen, what's been admitted?
Sure, I'm sorry, what exhibit number is it?
This is going to be number 155, and I just need to.
Okay.
Okay, so number 155, do you recall seeing this exhibit when Mr. Keast was speaking with you?
Yes, he showed the bottom email portion.
Okay, and the bottom email is from May 13th of 2021, correct?
That is correct.
And the issue on this day was a teacher wanted you to speak to Mrs. Crumbley's son to see how he's doing because he was failing class and trying to sleep all the time, correct?
Yes, it states he is failing my class and tries to sleep all the time.
Now, on this issue, on May 13th of 2021, I may have missed it. You don't recall meeting with Mrs. Crumbley's son to see what was going on, do you?
I do not have memory of this meeting.
Do you not have memory of the meeting, or did you not meet with him? Do you even know?
I do not have memory of the meeting. Evidence that has been researched suggests that I did meet with him.
At that time, in May of 2021, you did not call Mrs. Crumbley to discuss this falling asleep and failing a class, correct?
To my memory, I did not.
Thank you. I'm going to go to the next exhibit, which is number 156. Okay, and it's popping up on the screen. So number 156, this is from September of 2021, so a couple of months later, correct?
Yes, and the next school year.
Oh, that's what I was going to say. So the May would have been the end of one school year, and September would be the beginning of the next school year.
Yes.
Okay, in September, on September 8th of 2021 specifically, the Spanish teacher asked you to check in with Mrs. Crumbley's son because he had written a poem that said he felt terrible that his family is a mistake, correct?
Yes, that is what she wrote in the email.
Now, on this occasion, in September of 2021, did you speak with Mrs. Crumbley's son?
No.
You did not. Okay, so then it would also be fair to say that you did not call Mrs. Crumbley herself and let her know that this concern had taken place.
Yes, as I stated earlier, I followed through with the teacher
Okay.
on this concern, and she gave me further clarification of what
Okay, so at the end of the day, after further clarification, all said and done, this September 8th date, you did not place a phone call to Mrs. Crumbley.
Correct.
You did not email her or, I suppose, communicate with her in any way, correct?
That is correct.
I'm going a couple months later, we saw Exhibit 157, and I'm gonna go ahead and put that up on the screen. Now, 157 is the emails dated, it looks like November 10th of 2021. This was an email from the Spanish teacher to you indicating that Mrs. Crumbley's son is having a rough time and may need to speak with you, correct?
Yes, that she writes he is having a rough time right now. He might need to speak with you.
And on this occasion, you did speak with Mrs. Crumbley's son, correct?
I did.
This was the occasion where you saw him in the hallway and had a conversation with him, correct?
Yes, I caught him during passing time where there are a couple of minutes in between classes and let him know that if he needed someone to talk to, that I would be there.
Okay, so you talked to him, offered support, let him know where he could find you, correct?
Correct.
Now, on this occasion, in November 10th of 2021, after speaking with Mrs. Crumbley's son, you did not call Mrs. Crumbley, correct?
I did not.
You did not email Mrs. Crumbley about what took place with her son, correct?
I did not contact her in any way based on this email.
Now I'm going to go to November 29th of 2021. This was admitted as People's Exhibit 158. Yeah, I've got it up on the screen. And this appears to be an email chain between you and Mrs. Cabina. Is that correct?
Yes, she sent me, this is actually just saying that she forwarded the message. This is not the message.
I apologize. This message, however, that's forwarded makes you aware that Mrs. Crumbley's son was looking at different bullets in his first hour class, correct?
Yes, I do not have that email in front of me right now. So I don't have the exact wording. There it is.
I'm sorry, it's page 2, so I just had to scroll down.
Thank you. Yeah, so it's alerting our Dean of Students and Ms. Fine that there was a student in first hour who was on his phone looking at different bullets at the end of the hour.
Now, on this date, on November 29th, 2021, you did witness Miss Fine leaving a voicemail letting Mrs. Crumbley know what happened, correct?
That is correct. I witnessed Ms. Fine calling Ms. Crumbley and then leaving a voicemail regarding a conversation that happened during school.
And this jury has already heard the voicemail. We can agree that there is no request by Ms. Fine or the school that Mrs. Crumbley return the call, correct?
I don't remember the voicemail because I have not listened to it. It would not be odd to me if there was a request or not a request.
Thank you. Now, in that voicemail, I'm sorry, I'm not going to ask you about the voicemail. At the time of this issue of looking at bullets, you and Pamela Fine discussed this issue, correct?
What do you mean by discussed? I'm not sure I understand.
I'm assuming and asking, did you and Ms. Fine discuss the fact that Mrs. Crumbley's son was looking up bullets?
Are you asking in reference before the student arrived?
Yes, before or when the student arrived, either.
There was not much time between me getting there and the student arriving. The context of the meeting was largely led by Ms. Fine to gain an understanding from the student's perspective of what was going on at the end of the hour. first to see if he was going to be forthcoming with the truth, and then to see what was actually going on and what his reasons for doing so were.
And when you guys spoke with him about the bullets, there was also discussion about other things people may look up on the internet that are not illegal, but just not appropriate during school hours, correct?
There was discussion about school appropriate behavior, yes.
And overall, Mrs. Crumbley's son was told looking at bullets not appropriate for school, correct?
Yes, looking at bullets is not appropriate during school.
And beyond that, there was no further disciplinary action taken by the school other than just a notification phone call, voicemail to Mrs. Crumbley.
To my knowledge, but I would not be the one making the disciplinary decisions.
As far as you know, though, that was the end of it.
That was the end of my involvement in it.
Okay. Now I'm going to turn to Exhibit 159. This was admitted when you testified, and this is an email that appears to be between Allison Karpinski, and this was sent to you by Ms. Karpinski. Do you recall this email?
I do.
Now, this email is dated on November 30th, 2021.
Yes.
Correct? And we agree, November 30th, 2021 is the day that ultimately becomes the shooting, the day of the shooting.
Yes.
And this email was sent at 8:05 a.m. by the teacher to you.
Yes.
And specifically mentions that Mrs. Crumbley's son was watching videos on his phone of a guy gunning down people, correct?
It says that today he is watching videos of his phone of a guy gunning down people, and to continue, she writes, it looks like a movie scene and not security footage / a real event.
Okay, so she represented that it looked like a movie scene. It doesn't look like a real event. Okay, but she mentioned that it's definitely still concerning, correct?
Yeah, she says when taking into account some of his other behaviors, that she found it definitely still concerning.
Now, when did you become aware that Mrs. Crumbley's son was watching these concerning videos?
When I read the email.
At 8:05 in the morning?
I did not read the email at 8:05. I believe I read it approximately 30 minutes later.
Okay, so you would have read this email at approximately 8:30 that morning.
Around that time, yes.
Now, when you read the email at 8:30 that morning, you did not call Mrs. Crumbley's son down to the office to ask him about these videos, correct?
I was on the phone at the time with other parents.
So you did not call Mrs. Crumbley's son down to ask him about the videos. That's fair, correct?
I did as soon as I was able to.
Okay, so there's a time lapse between when you got the email and when you were able to speak with Mrs. Crumbley's son.
Yes.
Now, when you spoke to Mrs. Crumbley's son, you did not ask him to bring up the videos and let you watch what he was watching, correct?
Correct. I asked him what he was watching.
And you relied on the information he provided to you about what he was watching.
Exactly as I would if I asked him to show me the videos, yes.
I'm sorry, I don't understand what that means.
I was relying on him to provide the information, which would be the same as if I had asked him to show the videos.
Okay, but if you saw the videos, you would know specifically what they look like. You are instead relying on what Mrs. Crumbley's son says was on the videos, correct?
Yes, I asked him what they were, and he told me what they were, and I relied on the information he gave me.
When he told you what the videos were, the information you relied on, did he tell you where he obtained those videos from?
No.
Do you have any idea, or did you ask, how long he was looking at those videos for?
I did not.
Now, on November 30th, so about an hour after the time period we just discussed, that was when Miss Morgan made you aware of this math paper that we've discussed extensively in this trial, correct?
Ms. Morgan did not make me aware of the math paper. She made Mr. Ejak aware of the math paper.
I apologize, and then was it Mr. Ejak that made you aware of it?
Yes.
Okay, thank you, and thank you for clearing that up. Now, your testimony, you testified about the math paperwork, your observations, your thoughts about it on a couple of occasions over the last couple of years. Is that a fair statement?
Yes.
And when you saw the original photograph, or the original math paper, we can agree that there is a gun drawn on the math paper.
Which one are you referring to as the original?
I'm speaking about the one, let me put it up on the screen. It would
Thank you.
be, it's within Exhibit 160, and it's the prior to alterations, the math paper. Do you recall seeing this?
There you
Oh,
go.
okay. Yes, I was sent this in an email approximately 30 minutes into our meeting.
Okay, now, when you saw, did you see the altered math test first, or did you see I called this the original. There's also one, because, let's just be clear here. The shooter drew on a math paper, and what we see on the screen is that original drawing and writings. Is that correct?
What you see here is the photograph taken by the math teacher,
Of the original paper.
as it was when she had it, yes.
And then after she had it, the shooter wrote more on the paper, and we ended up with a second math paper that is essentially the original math paper plus some writings on it, correct?
Well, it's doctored.
Doctored. Okay, right. So I'm going to call this the original, and then I'm going to call the other one with the additional writing the altered version. Is that okay with you?
Understood.
Okay, for the purpose of questioning. Okay, now, I'm going to open up the altered version as well, which was admitted as Exhibit 123, okay? So it's fair to say that you are familiar both with the original math paper and with the altered one, correct?
I was able to look at both of them over the course of our meeting, correct.
And when you look at both papers, it's very clear that Mrs. Crumbley's son drew a picture depicting a gun, correct?
Yes, and the one especially that has no scribbles over it, I would not say that without context that it would be very clear on the altered one that that is a gun. Without context of the original.
Okay, I agree with you. So you're saying that the first photo on the left of the screen, it's clearly a gun, but when he altered the drawing, he crossed it off so much you might not know that had been a gun drawn there.
Correct.
Okay, when you saw the gun drawn on the sheet, seeing that gun, even just seeing the gun, that was not enough to make you believe that Mrs. Crumbley's son posed a risk to himself or other students, correct?
I wasn't sure whether he posed a risk to himself, so that is why I called in the parents.
Okay.
I was concerned, and I wouldn't call in parents unless I was concerned.
Okay, so you called the parents in because you were concerned, but we can agree that seeing the drawings, just the drawings alone were not enough for you to conclude there is something dangerous to other people.
When I take that in context, that is only a piece of the information I had. I also was looking at his demeanor throughout it. I also was asking questions to him, asking if he was a threat to himself or others, and taking his response of sadness, which is not a common threatening response.
Okay, and it's, in all fairness, and you've had lots of training on this, correct?
I have had training on this.
So you've been trained, you've been formally trained on how to assess this kind of information and how to deal with it, correct?
Correct, and the number one way that I would be dealing with it would be to entrust the care to parents.
To entrust the parents with the care of their child.
Correct.
Okay, so there was talk at some point in the materials from this case about a step 1, step 2, step 3. Do you know what I'm talking about in terms of evaluating a suicide risk?
I don't know what direct thing you're referring to.
Okay, are there certain steps, if you do have concern, that you follow if a student is exhibiting what you called suicide ideation?
Well, suicide ideation is very different than actively suicidal.
Okay.
So I wonder if what you're describing might be an active suicide checklist as opposed to what we do if we see suicidal ideation.
Well, what do you do if you said in this case you were concerned about suicidal ideation, correct?
Yes.
So what do you do when it's a concern of suicidal ideation?
I call the parents.
Call the parents. Okay, and that's what you did obviously in this case.
Yes.
Okay, and one of the questions I do have for you, and I'm just going to page 72 from the civil deposition. This is just for you guys. Page 72 of the civil deposition is where I'm getting this question from. A drawing of somebody who is shooting a gun is just a drawing. That is something you've said before, correct?
I do not remember.
If there's not another person in the drawing, that's of significance to you when you see a picture of a gun, correct?
Are you referencing in regards to the math assignment?
Yes.
In the math assignment, if I see multiple people, I do have a different level of concern.
Okay, so explain for us then what, and I don't know why that clicked off, but it's going to pop back up. So explain to us what you mean by when you see another person or you don't see another person. Tell us what you see up here and how things would change if there were multiple people.
Well, I see one body. If I see somebody holding the gun in one body, my response is completely different.
Okay, so, and have you had training about looking at drawings by students and being able to take them into account when you're assessing situations?
I've had training in how to assess situations. I would not say I've had training in students' drawings.
Okay, but your conclusion was that because there's not a second person, seeing a gun on these pages in and of itself alone would not be enough to cause you concern.
Again, you're taking a very small piece of that. That is just a piece of what I saw in totality.
Okay, so you were asked before, you didn't see anything that suggested that there was a gun in the hand on this drawing, and your answer was no, correct?
In regards to this drawing,
Yes.
I do not see a gun in someone's hand on this drawing.
Okay, you were asked, that's a pretty important thing for you to know or not. Do you agree? your answer was a drawing of somebody who is shooting a gun. Still, there's not another person. It's just a drawing. Do you recall testifying that way when you were previously asked about this drawing?
That was not in regards to this drawing.
It's fair to say that, which drawing was it in regards to then?
Not this one.
So you testified at a deposition on September 14th of 2022, correct?
I believe that was the date, correct?
And there are, the discussion prior to those questions was about the drawing in class that day, and the drawing being on the violent side. Do you recall that?
In regards to the email from the teacher that we discussed earlier, yes.
Okay, so at the end of the day, your prior testimony that seeing a drawing of a gun, that in and of itself, by itself, does not create enough of a concern that something more sinister is happening, correct?
We are looking at a total picture and not just a piece of a picture.
And you are trained to look at that total picture, correct?
I took the approach to look at the total picture.
In addition to looking at the total picture, and by picture I'm saying the picture that was drawn, you also look at the picture in terms of the demeanor of the person you're speaking to, the way the person is presenting, the way the student is behaving, a number of factors, correct?
I try to take in as much information as I can.
And taking in as much information as you can is certainly something that you have learned to do through, in addition to your training, your experience, correct?
Yes.
This is not the first time that you're calling a student down to your office to talk to them about something that may be problematic, correct?
Well, and that's why I was not the only one in the meeting, was I didn't want to take the approach of I was the only one making the call. I also had our person in charge of discipline with me.
And so you are in the meeting, and when you're saying the person in charge of discipline, you're talking about Mr. Ejak, correct?
Yes.
And Mr. Ejak is going to testify, but your understanding is that Mr. Ejak has also had training on dealing with these kind of situations, correct?
I do not know his total background.
You would assume that as the assistant dean of school of the school,
I'm just
he's had
objecting to the
training.
question of this witness. Mr. Ejak will testify. It's appropriate for him.
I'll withdraw the question, Your
Okay,
Honor.
yeah, he can answer that, Mr. Ejak.
Now, when you asked Mrs. Crumbley's son about the videos he was watching, he indicated to you that he wanted to be a video game designer, correct?
He did.
And he actually had a detailed conversation with you about an opportunity that Oxford has for students to get training to become video game designers, correct?
I showed him a program through Oakland Schools that could lead him into that area.
Okay, so you and Mrs. Crumbley's son had a conversation about if he was interested in pursuing a video game designer career. The school system even has opportunities for him to further that interest.
Yes.
And in that conversation, when you were speaking to Mrs. Crumbley's son, you believed he had a genuine interest in this video game designing future.
Yes, I did.
If you believed that Mrs. Crumbley's son did not have a genuine interest in becoming a designer, or that he really was drawing pictures with a plan to hurt people, you would have certainly taken different actions, correct?
If I believed that he was a threat to people, I would have taken different actions.
Now, you testified about when the parents came in and this meeting that you had with them. You obviously recall that, correct?
I do recall the meeting.
Now, when you met with the parents, they were present for approximately 12 minutes out of the entire time you spent with Mrs. Crumbley's son.
Yes.
And you testified that you were with Mrs. Crumbley's son for approximately an hour and a half, correct?
Correct.
So it would have been an hour and a half, including those 12 minutes.
Yes.
Now, prior to that hour and a half spent with Mrs. Crumbley's son, you had never spent any kind of time, really, aside from short conversations with Mrs. Crumbley's son, correct?
Correct.
And you also had never spent time with Mr. or Mrs. Crumbley talking to them about or handling matters regarding their son, correct?
Correct.
So when Mr. and Mrs. Crumbley arrived at the school and were communicating with you on this issue, these are not parents that you're seeing on a weekly or even monthly basis, correct?
Correct.
I imagine at the school there are other situations where you have students that are essentially frequent flyers down to your office, correct?
I do know some students more than others.
And some of the students that you deal with more frequently, you're also used to dealing with their parents on a more frequent basis, correct?
Potentially correct.
And the more times you have to deal with the parents and the more times you have to deal with their child, the more you get to know about the family and the dynamics of the relationships, correct?
Yes, I would hope the more time I spend with someone, the better I know them.
So when you are talking about how the Crumbleys greeted their son or did not hug their son, it's fair to say that you are not aware, you've never really seen the Crumbleys greet their son on other occasions, correct?
Correct. I'm not making a judgment on normal. I'm simply stating what happened.
Okay, and that's completely fair. And I just want to confirm, though, that in terms of when you're making the observation, there was no hug or a certain kind of greeting. You also you haven't had the experience of seeing the Crumbleys greet their son on other occasions.
Correct.
And it's also fair to say that when parents come into the office, parents all may have a different reaction about their child being down in the counselor's office or in the principal's office, correct?
Well, first I would say those are two very different places.
Okay.
But no, you don't expect all parents to respond in the same way.
You get parents who are angry at their child as they're walking in the door, right?
Rarely.
Some people are coming in and have more of an anxious look.
They could.
Some parents may come in and just seem like this is no big deal.
Again, all parents could respond differently.
Okay, so there's any number of responses, and in the end, and if your training says any different, let me know. There is no right answer about specifically how a parent should respond to going to a school counselor's office or going to a school principal's office.
Yes, again, I stated I'm not making a judgment. I'm simply stating what happened.
Thank you. Now, the dates that we talked about are dates where, obviously, through the course of this investigation, you identified emails where you were involved with Mrs. Crumbley's son. Is that a fair statement?
I'm not sure what your question is.
Did you provide the emails that we talked about and that were admitted as exhibits?
Did I provide them? The Oakland County Sheriff's Department had full access to my email.
Okay, did you at any point go through your emails to take a look at any emails related to Mrs. Crumbley's son?
On the night of the shooting, I did, with a police officer, go through and search for anything I could think of from that day and print and hand them to him.
Okay, and then ultimately, any of these other emails we've seen were discovered by law enforcement?
Yes, there's been a full cooperation with that.
Okay, and I'm not trying to allege you haven't been cooperative, I'm just asking that those emails, obviously, I imagine all your emails are stored on some kind of a system. Would that be?
Not my area.
Not mine either. This jury learned about my technology abilities on Friday. I want to just turn your attention to a couple of dates. On March 8th and March 9th of 2021, you didn't have any experiences with Mrs. Crumbley's son related to needing counseling or being called down to the principal's office, correct?
I don't remember any.
Okay. On March 16th, which was a Tuesday, March 17th, Wednesday, 18th, or 19th, you don't have any incidents on those dates with regard to Mrs. Crumbley's son either,
I don't remember any.
okay?
I don't remember any.
Okay? If there had been incidents involving Mrs. Crumbley's son on these specific dates, would you assume they would have been included in the emails of all the other dates that were included about?
If there were emails of them, they would have been included.
Okay, so we don't have any emails of March 16th, 17th, 18th, or 19th, correct?
To my knowledge, no.
We didn't see any emails or concerns that arose from, well, this is a Saturday, so probably not likely, Saturday, March 20th, correct?
I don't know of any.
Sunday, April 4th,
I don't know of any.
not even the next day, Monday, April 5th?
I don't know of any other meetings aside from the emails that have already been presented.
Okay, so then in all fairness, when I'm April 29th and November 4th, same thing, you don't have any awareness of any of these days?
I don't know of anything specific towards those days.
Okay. Now, you testified that it was your hope that Mr. and Mrs. Crumbley would take their son home and get him into a counselor that day, correct?
Yes.
When you had that hope, you gave them a list of counselors to suggest they call, and noting which ones took various insurance programs, correct?
Yes, I provided a list of resources.
Now, in terms of getting a counseling appointment within one day, you don't have any knowledge if those counselors on that list could guarantee a same-day appointment, correct?
I don't know counselor schedules, and I can't speculate on what they would have had.
Is it fair to say that in the post-COVID time of 2021, mental health services have become more difficult to obtain appointments? And if you don't know and you're not the right person to ask, just let me know.
I don't work in community mental health, so I can't make that statement.
Have you personally had to call to schedule therapy-type appointments for anyone?
I experienced a shooting. I called to cancel to get therapy for myself.
Okay, and when you called to get therapy for yourself, it was obviously a very, very urgent situation.
I mean, it was a pretty impactful situation, yes.
Okay, and did you end up seeing a counselor on the 30th?
No, I was cooperating with law enforcement and still in our building on the 30th.
Okay, so your appointment was sometime after the 30th, correct?
It was after the 30th.
And sometimes when you call to get a counseling appointment, it's not unusual to have to wait a couple of days or to schedule it, correct?
I think we're getting a little hypothetical with this, and I can't speculate on what's usual or not for counselors in this area.
That's fair enough. I appreciate that. When you were speaking with Mrs. Crumbley's son, it's fair to say that you and Mrs. Crumbley's son discussed whether he wanted to stay in school that day or go home prior to the arrival of Mr. and Mrs. Crumbley. Is that correct?
That did come up, yes.
And Mrs. Crumbley's son's position was, I want to stay in school, correct?
Correct.
COVID had been hard on him. He didn't like virtual learning. Was that your understanding?
He did state those two things, yes.
And there was discussion when the parents arrived that missing school is a source of anxiety for Mrs. Crumbley's son. Do you recall that?
I do.
So before Mr. and Mrs. Crumbley even got there, the option for Mrs. Crumbley's son to stay in school was on the table.
Well, there is no option of staying in school. School is a requirement unless you meet certain standards in which it is no longer available to you.
Okay, if a child gets sick at school, at Oxford High School, and vomits, okay, are they allowed to stay in school the rest of the day?
I don't know. That's not something I deal with.
Okay. Are you aware if a child has a temperature, if they are allowed to stay in school? And if you're not aware, let me know.
If they are allowed to stay in school,
Yes.
if we didn't, like, again, hypothetical, but not my area, I don't send students home.
Okay. Are you aware if the school will tell parents you need to take this child home if they are sick at school, physically sick?
The only time I remember that being a discussion was during COVID.
Okay, during COVID, were kids who were exposed to COVID allowed to be in school?
No, because we were following rules and regulations outside of the school.
So even if parents said, I want my child to be in school, he has COVID, but I want him to be there, that's not allowed, right?
Judge, I have to object to relevance now. We're awfully far afield.
No, I think he said that that's not up to him, that's maybe,
Correct.
is that up to like the school nurse or some person like that?
There is no school nurse. The COVID tracing was not through the school, that was through the county health department.
All I'm asking is, there are times where if a child is sick, it's not an option for them to be present in school.
When the county health department regulated that, yes.
Okay. And you testified that if there had been a discipline issue as to Mrs. Crumbley's son, that may have been grounds to make him have to go home that day, correct?
That could be the case depending on the discipline issue.
And in terms of the discipline issue, I realize you're not the discipline person, but the school has the option, depending on what's correct, they could suspend a student, they could expel a student, there's processes over school discipline, correct?
There is a process. I am not a part of that process.
It's your testimony, though, that in this case, the school did not find a discipline issue with respect to to Mrs. Crumbley's son.
That is correct. There was nothing that was determined as a discipline issue.
So it was not a discipline issue that he was looking up bullets on his cell phone during a class.
I would not be the one making that determination.
In this case, that was not something he was disciplined for by the school.
I already stated I was not a part of any potential disciplines. To my knowledge, no.
Same thing with watching videos on a phone. The school did not make a discipline issue that would cause Mrs. Crumbley's son to go home for sitting and watching videos on his phone during class, correct?
There was nothing that was determined to be a discipline issue.
And Mrs. Crumbley's son sitting and drawing on math paper instead of actually doing the math paper he's supposed to be doing, as far as you're aware, the school also didn't find there to be a disciplinary violation for that.
Judge, Mr. Huffman already testified that discipline is in this area, that's Mr. Ejak's area.
He doesn't make that determination, he said.
I'll ask Mr. Ejak then when he testifies. Now, you did testify that one important thing was that you did not want Mrs. Crumbley's son to be alone after you thought he was so sad and experiencing so much sadness, correct?
I did not feel that it was wise for a student with signs that could be suicidal ideation and things that I saw as suicidal ideation to be alone.
Now, when you spoke to Mrs. Crumbley's son, he also wanted to be around other peers that afternoon.
He stated that he wanted to be in school. I don't remember him specifically stating anything about other peers.
Do you recall telling Mr. and Mrs. Crumbley that it would be good for him to be around other peers versus being alone?
I don't remember specifically stating that to them.
Is that something that you believe, or, and if you can't answer the question, just please let me know.
What is your question?
My question is that something that you believe, that it would have been better for him to be around peers that afternoon versus being left home alone?
It's the judgment call I made.
I'm sorry, what was that?
That is the judgment call I made, was that I felt it was better for him to be around peers and people who are his age than to be home alone.
Thank you. May I have just a moment, Your Honor? I have no further questions. Thank you, Mr. Hopkins.
Redirect.
Thank you. Mr. Hopkins, you were asked about the total picture by counsel, so I'd like to go through that with you. On November the 30th, when you met with Jennifer Crumbley, did she tell you that on March the 9th of 2021, her son had texted her that he was seeing demons and bowls flying off the shelf?
I did not.
Okay, so did Jennifer Crumbley tell you that on March the 17th, her son had also texted her that he was hallucinating?
No.
Did Jennifer Crumbley tell you that on March the 20th, he had texted his mother that he was hallucinating?
Your Honor, I would ask that the prosecution stop the leading questions.
Judge, I'm just trying to get through redirect in a timely fashion, and this is specifically in response to her.
I don't know how you can ask it another way.
I'm not suggesting the answer, Judge. I'm just.
Yeah, he's not suggesting the answer. He's asking a specific question. It's a yes or no question, right?
Thank you, Judge.
He's not suggesting the answer, so.
Thank you.
If you could read the last one.
Sure. Did Jennifer Crumbley tell you that her son texted her on March the 20th, 2021, that he was hallucinating?
No.
Did Jennifer Crumbley tell you that in April of 2001, she had told a friend of hers that she thought Ethan was depressed?
No.
Did Jennifer Crumbley tell you that she had referred to her son as weird?
No.
Did Jennifer Crumbley tell you that she had never once set an appointment with any mental health professional?
No.
Did Jennifer Crumbley ever tell you that his only hobby was involving firearms?
No.
Did Jennifer Crumbley ever tell you that she posted on Instagram as early as June of 2021 that he had obtained his own handgun?
No.
Did Jennifer Crumbley ever tell you that the day before the shooting at 3 o'clock in the morning, she herself was researching clinical depression options?
No.
Did Jennifer Crumbley tell you that she and her husband gave her son a 6-hour 9mm handgun just 4 days before the shooting?
No.
Did Jennifer Crumbley ever tell you that on November the 30th, 2021, it wasn't the first time he asked for help?
No.
Did Jennifer Crumbley ever tell you that the gun that he drew on that math worksheet was identical to the 6-hour 9mm handgun that was
Your
used in
Honor,
the shooting?
I object to the prosecution's characterization that that drawing is identical. That's a conclusion that,
Sustained.
That's fine. Did Jennifer Crumbley ever tell you that the day before, on November the 29th, on that Monday, the day before, after the voicemail was left for her from Pam Fine, she texted her son and said, LOL, you have to learn not to get caught?
No.
Did Jennifer Crumbley ever tell you that James Crumbley worked for DoorDash and had no obligation to not take their son home?
No.
Did Jennifer Crumbley tell you that on November the 30th, she was permitted to leave work when she needed for family issues?
No.
Did Jennifer Crumbley tell you that on November the 30th, the meeting that she allegedly had in the afternoon, she was not required to attend?
No.
Did Jennifer Crumbley tell you ever that their son was struggling throughout the year 2021?
She confirmed it based on what he had said regards to COVID and virtual school.
But they never went through these details.
Not these details, no.
So it took you all about 20 minutes to decide to request Jennifer Crumbley to come into the school immediately. Is that what you testified to?
Yes.
Is that the total picture that you wish you had?
No.
Now, what if Jennifer Crumbley had told you all of these things I just went through?
Your Honor, objection is to speculation, and
Sustained.
hindsight is 20/20.
Sustained.
Would you like to have as much information as you possibly could have?
Absolutely.
Was their son still in the room in your office when the defendant said she couldn't take him home?
Yes.
Nothing further.
All right, you can step down. You're excused. You guys want a break? Okay, so we're gonna take like 10 minutes, okay?
All rise for the jury.
Okay, you may be seated. Who's next?
We need to confer.
Okay.
Sorry,
10
I'm not
minutes.
trying to hide anything, we have some time issues.
Okay.
Can I have just the option so I can get my folders at least out?
As soon as we know.
So, yeah.
So this is.
10 minutes.
Okay, then I'm
We need
gonna
to
have
make
to
sure
have
we
a-
have the right person.
I'm
All right. So I wanted to, while we're waiting here, discuss a little bit here, some of the comments here. And I think it's telling here, absolutely, with the witness we just saw. I mean, I think it's just absolutely explosive, like we were talking about here, of how, with this witness having testified, he's a trained counselor. He's reviewing the situation. And I understand she knew other things going on, but that moment, his recommendation is he clears the way and says, yeah, he thought it would be great for him to go back and be around students. When you get into the instruction here, and let's get back up to the instruction here. I'll get that queued up here. All right, so we have the instruction here. So, when you apply this here, again, what you heard the prosecutor talking about here was this, and we're getting to let me come down here to the explanations of, no, not contributing negligence, degrees of negligence. So the state is alleging that ordinary negligence means not taking the responsible care under circumstances as they were at the time. That's the definition of ordinary negligence. If the state can prove that that her negligence in this case rose to ordinary negligence. Now, slight negligence is not guilty. That would mean doing something not usually dangerous, something that only an extremely careful person would have thought could cause injury. In this case, if you find that the defendant was only slightly negligent, you find her not guilty. Ordinary negligence means, and this is what they're alleging in this case, this will be the instruction given and what you should be judging the case by. Ordinary negligence means not taking reasonable care under the circumstances as they were at the time. If someone does something that is usually dangerous, something that a sensible person would know could hurt someone, that is ordinary negligence. If the defendant did not do what a sensible person would have done under the circumstances, then that is ordinary negligence. The issue here is what a sensible person would have done. So the state's going to allege she had a set of facts and circumstances in her mind that separates her from this trained professional. But the idea that in that moment, with everything that's going on, the way, most parents are going to look at the behavior of their child, not as a potential school shooter. He never expressed that to her, but as, okay, yeah, he's having problems and he's acting out. And she's looking up. We don't know if she was looking up depression for herself or depression for her son, but depression doesn't rise to school shooter. And who's going to think he's going to go, shoot up the school, besides the fact he was writing it? But this professional who's reading this, who's a sensible person, right there in the room with her, agrees with her. So this is the issue that they have to do or have to deal with in this case. But they're back in court, so let's jump over and start watching again.
Who's next witness?
Sergeant Joe Bryan.
Do you swear or affirm the testimony about to give, or is it please I'll have to go?
I do, Your Honor.
Okay, so step up, have a seat, and state your name for the record, spell your first and last name.
Joe Bryan, Joebrian.
Go ahead.
Thank you. Sir, how are you employed?
Employed as a detective sergeant with the Oakland County Sheriff's Office.
Okay. Can you keep your voice nice and loud for us, please?
All right.
Thank you. Sergeant, where do you work within the Sheriff's Office?
I'm assigned to Special Investigations Unit.
Okay, what do you do there?
We conduct major investigations, internal affairs, assist a lot of other departments, anything kind of big we at least help out with.
Okay. Now, November the 30th, 2021, were you working that day?
I was.
Okay. Were you assigned to assist in the investigation of the Oxford High School shooting?
I was.
Okay. And at this time, how long have you been with the Sheriff's Office?
At that time, 27 years and some change.
Okay. So you're with the Special Investigative Unit now. Where did you work prior to that?
Same spot since 2011.
Okay, what about prior to that?
I ran the computer crimes unit for about 8 years. Prior to that, sergeant in jail, sergeant or detective out in Highland, and then the jail. And
Okay. All right. So, did you actually respond to the Oxford High School shooting scene? Did you respond to the shooting scene itself?
not initially.
Okay. Were you directed to the Oxford substation, the sheriff's office?
I was
Okay, and for what purpose?
to attempt to do some interviews.
Okay. Now, by the time that you had arrived at the Oakland County Sheriff's Office substation in Oxford, was the school shooter already in custody?
Yes, he was.
Okay, and was he brought to that location?
He was.
Okay. And during the course of your investigation, did you learn who the school shooter's parents are?
I did.
Okay. And his mother is Jennifer Crumbley?
She is.
She's in court today?
Yes, she is wearing the dark blazer. At the defense counsel.
The record will reflect the input identification of the defendant, Jennifer Crumbley.
Thank you. Once you learned who the school shooter's parents were, did you attempt to speak with those individuals?
I did.
Okay, and tell us how that came to be.
I called him up and had him come to the substation to talk to me.
Okay, so you learned the identities of James and Jennifer Crumbley, and you made a phone call.
Correct.
Okay, so on Friday, we introduced evidence of call logs that showed you contacted James Crumbley about 1:50 in the afternoon, November the 30th. Does that sound accurate to you?
That sounds about right.
Okay. And when you made that phone call, what did you tell them to do?
Just come to the substation.
In Oxford?
Yes, sir.
Okay, and did they arrive there?
They did.
Do you recall approximately the time they arrived there?
Probably around 2. We didn't wait much for them to get there.
Okay. And again, on Friday, there was evidence of their GPS data locations that indicate they were there at 1:58 p.m. Does that sound accurate to you?
Yes, sir.
All right. When you conduct interviews with individuals pertaining to investigation, criminal investigation, are those interviews generally recorded?
Most of the time.
Is that audio recorded as well as video recorded?
When available, yes.
Okay. Does the Oxford substation, the sheriff's office, have the capability to record interviews in such a fashion?
They did and do.
Okay. So on November the 30th, 2021, did you interview both James and Jennifer Crumbley?
I did.
Okay. And was that interview recorded?
It was.
Have you had the opportunity to review that recording?
Yes, sir.
Okay. Does that recording fairly and accurately depict your interview with James and Jennifer Crumbley on November the 30th, 2021?
It does.
Judge, that's People's 340. People move to admit.
We have no objection.
340 is admitted.
Thank you, Judge. I'm going to play it for the jury, but before we do, I just want to confirm with you, Sergeant, that the recording that we're going to introduce as evidence is Exhibit 340. It has a date and time stamp, is that right?
Correct.
Okay, but that time stamp is actually an hour off.
That's correct.
Okay, is that daylight savings time?
I don't know why that's
Okay.
an hour. I really don't.
That's fair. But we know that they arrived at 1:58 in the afternoon, and did you speak with them immediately after they arrived?
Yes.
Okay, so that would be the time you spoke with them, not 2:58.
Correct.
Okay, thank you.
How long is it, Sergeant? Do you know?
The video?
Yeah.
Like 15 minutes probably.
It's
Not
around,
very long.
around 20 minutes or so.
Okay.
So Sergeant, as I get this queued up, this would have been right after they found out that their son was taken into custody for the Oxford High School school shooting?
Correct.
Just so we can identify everybody. This is you in the blue shirt,
It is.
and the individual to your left in the video is who?
My partner, Rob Miller.
Okay. Individual with the hat,
James Crumbley.
and the female in the video.
Jennifer Crumbley.
Okay. And again, this is 1:58 and 59 seconds, November 30th, 2021.
Yes, sir.
Obviously, we don't know all what happened yet, they're still ongoing. Our understanding, he wasn't involved in a school shooting, he was the one who did everything.
he was doing on a test, or a practice test.
Do you think we should talk about a lawyer?
That's up to you.
I think we probably should have a lawyer.
I think we can speak
I know.
to the cops, and
Just
we'll
be
answer these.
And here's our perspective right now, this thing is still very, very fresh.
right.
Right, people are still on their way to the hospital and such. We need to know what his state of mind is. Is there explosive devices anywhere? Is there other guns anywhere? Did he hide guns, ammunition, explosive devices? Are there any other victims? We need to know these things quite rapidly.
I was in town. I saw all you guys go to Ontario. When I see 5, I start concerned. I headed to the high school, obviously couldn't get to the high school, turned into the Meyer parking lot, and I saw these kids standing outside. I'm trying to call my son, make sure he's okay, and
He texted me that he loved me.
He actually did it.
And somebody said that there was an active shooter.
35 minutes
I
before he called me,
immediately,
I was
freaked out
I was
because
down
of
to the school.
the
He
situation.
was drawing that on the paper and the counselor called it down.
So really, what did the text say?
No, but it was texted to me
Oh.
from the counselor.
Counselor.
I texted Ethan at 12:21, you okay? He said, yeah, just got back from lunch. I said, you know, you can talk to us, we won't judge. He goes, I know, thank you, I'm sorry for that, I love you. I said, I love you too. And then, you okay? And you're back. And then, then he told me about what's going on, and I freaked out when I drove here from work. And that's where we're at.
What time did you text him?
That was at 12:21, and he was just getting back from lunch.
So you guys had a meeting with the counselor this morning over
Yeah.
the school?
Yeah.
I said, what year was this? What, was it the first hour, second one, what time was it?
I got to school at 10:30, I don't know whatever.
So it would have been earlier, first or second, I don't know.
And what did he say?
I mean, he just said he was sorry, he just said, you know,
Did he have an issue, like a smackdown?
No.
Or?
No.
not that we know of. His best friend, his parents just sent him somewhere to Wisconsin for an OCD rehabilitation. That was his only friend that he had. They hung out all the time, they hung out at school. Our dog, our Great Pyrenees, just passed away a couple months ago. My mom died back in April. So that's,
So you know what stressors going on?
They didn't.
They say, did you guys go over this with him, like, what is that, like, modals? Anybody asked him what the modal was?
No, the counselor just.
the counselor just said, you know, there's no,
I didn't even, honestly, I didn't even like think about that, because
I mean, it's Ethan, like, Ethan's like, he's a perfect kid, like, he doesn't do anything, he doesn't get in trouble at school, he doesn't, like,
is that how,
That's your, what kind of?
it's a 6-liter, man. It was hidden in our in the case, and bullets were hidden in a completely different spot underneath some jeans. I raced home.
Now, the guy missing, or you saw all the cops?
right
We live
across
on
the street.
I'm not familiar with that.
So, if you walk, it's gonna come to school. It's really right in the village.
So what we'd like to do, is talk to your son. And obviously you mentioned earlier, our lawyer, he is totally entitled to one. That's gonna be all up to you guys, because his age.
We would like.
I'm messaging Andy right now.
Okay.
Age,
Okay. Can Andy handle,
If Andy can get me something.
we would like a lawyer present
before we do any question.
from here on out. Okay. And there's no disrespect to you guys, it's just, we don't, I don't want to have on this one, I only see this stuff on TV.
That's cool.
All I know is I got talked to my counselor about that, they talked to me, and we went down there, and
That's all that was about.
that's all it was about. And he didn't seem worried about it, and he said he just more welcome to stay at school, or he could go home, and I really wish we
Would have taken.
get him home.
Is this, or is that?
You didn't help here.
For the time being, it'll be, he's done arrested once. He's going to, either jail or for his military for a short time. So we're going to talk to him, so. Any medical conditions, any mental conditions we need to be aware of?
He said to get some anxiety for a test, maybe there's something he can do.
Do you have any meds or anything like that that you have at home that you might need to bring through? No meds, no, is there no treatment for mental health, anything like that? Give me 1 second, I know we have a confinement form, there's maybe a lot of stuff we have to ask them, as far as just like weight and all that kind of stuff, and one of you guys can go with us.
Okay.
Yeah, no problem. Alright, so give me 1 minute to the form, I'll be right back. You're. Yourself the same. Any trouble with the law or anything?
Nothing.
Everything's suspended?
No, nothing. No, I mean,
The mediocre grades, I mean, they're up and down, you know, but
he got, I found out he had E in geometry last night, and I got on.
Somebody.
no, a grade, we were talking to him about his grade.
I got on to him last
I'm
night.
sorry, it's what?
His grade,
Grades, okay.
he was feeling geometry. And I got on to him. And I was all this.
Excellent. You need to get the. No, he's gonna be safe, okay? He's not hurt at all. It's gonna get worse or he's better. At this point right now, it's all pretty fresh. We don't know. Say that people are hurt, anybody's died, you don't know. At this point. Okay, but children. Family members we should check on, any family members you may be concerned about, CD grade, any family members that you want to hurt.
Well, I mean, she's gonna be in. It's just fine, it's in the school, we apologized about last night. We talked about his grades, told him, like, listen, we just want you to drop. Make sure you have, uncompleted assignments, that's all we want to do.
Do you sound great? Yes, so. Were they loaded bags? They were empty when you scored them? They were empty, the gun was empty, the bullets were in a completely different place. How many rounds was in it still? No. You guys bought 100 when you went to the shooting?
You bought 200.
I thought it was just a box of them.
Oh, I don't know.
He didn't.
I don't remember.
It wasn't an exorbitant amount of money, because you would have known.
How many? $56.
Okay, then he only bought 100 rounds. And so you guys spent 50. So, yeah, I mean, we go to the shooting range all the time. He goes with you, so he knows how to work the gun. He knows, yes. I've been trying to teach him safety, and, I mean,
It was a hobby that they did together, sure. Still not gonna release his name or anything.
he's a juvenile, they won't do that.
Hmm?
No, they will not. He's a juvenile, they won't release him. Eichner. Grayish. Aaron Donner. Okay, so we were gonna ask you a bunch of questions about why you did this and get your whole side of the story. Your parents wanted to retain insurance, so I'll be asking you any questions about the incident that you were involved in. Your parents popped in here to study some basic information. You will have a contact with them eventually. We'll be taking you to, I don't know, Oakland County Jail or Children's Village forthwith, get you lodged after we take all your clothes and everything else you have on you. Any questions for me? You have to ask me, it's up to you. If you want to ask me something, go ahead. I don't think we need to ask you any questions right now. Okay, hop up. I'll back up. You say your story.
Why?
I did. I love you. I love you. I love you. I love you. You guys can.
Didn't even like care. What the fuck?
Where you go? You have our information. Do you have any questions for us? So typically what happens is, now we haven't done you.
Somebody contact us and let us know where it's going to be.
Corporal. Yeah.
When?
A day or two. Could be today, could be tomorrow. Okay, little weekend, right? So right now, I really don't care about.
We understand, right?
So somebody will be in contact,
Okay.
because of his age. Yeah. Okay. I'll walk you up.
Sergeant Bryan, person we heard sobbing at the very end, was that the defendant or is that her husband?
Oh,
Your
James.
Honor, I would object. They're both crying at the end. I think that's misleading.
The only one who can
I
make
think
that
it's- okay.
is Sergeant Bryan.
Okay, well, he has personal knowledge. You can,
Yeah.
you can rely on the evidence that you see, okay? You can, all the evidence will be available for you when you deliberate as well, okay?
And Sergeant, we had some pauses in there. That's because personal information was being obtained from the defendants?
Correct.
Okay. Judge, I'm going to move to admit the transcript of the interview is Exhibit 424. The audio is a little bit garbled over the two TVs that the court has in the courtroom.
Any objection?
Your Honor, I have not seen 424. They have not sent it to me.
We can,
So,
feel free to take a look at my copy while we can,
Okay.
the court can withhold the ruling.
Subject to review, you can let me know in the next 2 days,
yeah,
okay?
absolutely, and likely, no objection.
Thank you, Judge.
I need to-
What,
I need to-
man,
Thanks.
what a dirty ass prosecutor.
All right.
You can look at my copy in open court.
That would be forced to revisit.
Yeah, let me know this thing.
Okay, we'll do.
Certainly. And Sergeant Bryan, what was your impression of the defendant's demeanor throughout the interview?
Atypical from what I'm used to on something like that.
What do you mean?
Your Honor, I would object as to the foundation, lack of foundation for this.
Hey, sure. Sergeant Bryan, you've been in the sheriff's office for 29 years now?
Yep, a couple months.
Okay. And you've been with the Special Investigative Unit for over 10 years?
Yes.
Okay, and you already told us that that is the unit within the sheriff's office that handles the major investigations.
Yes.
Okay, that includes internal affairs,
Correct.
and it includes homicides.
Correct.
How many interviews of either witnesses or suspects of crimes have you think you've been a part of?
5,000, maybe
Okay.
more,
This is something you do on a day-to-day basis?
every day.
Okay. And you described the defendant's demeanor as atypical?
Correct.
Okay, and tell us why.
Your Honor, I would have opinion when this is very grossly unfair and prejudicial.
That's argument. The counsel's free to
Isn't
make
the
that
best
argument.
evidence of how she reacted to the video itself?
Well, I think an officer with 30 years of experience is in a unique position to give that testimony.
I think the jury can decide for themselves. The jury's gonna see the evidence, they saw the videotape, they can decide if that her behavior is normal or not normal.
Thank you, Judge.
How do people, I guess you can ask, how do people react when your children, you know, you've had other cases with children being charged.
Yes, not a school shooting, but yes, I've had many cases where kids have done bad things.
Okay.
I've had to tell the parents.
And you've had to tell the parents of that?
Yes.
Okay. And what you experienced on November the 30th was not consistent with what you
Your Honor,
experienced in the
I
past?
object again, same thing.
That was the court's question.
I didn't hear the question.
I was just following up with the court's question, Judge, that in his experience, he's had the opportunity to interview parents of a juvenile who's done something illegal.
What's a common reaction that you've experienced?
Crying, disbelief, why, those
Your
kind of
Honor,
things, Your Honor.
Again, I object. It's irrelevant and it's prejudicial, and no other parents have had a child, their child, commit a school shooting. He just said, this is
Well, that's not
such a
true.
different case. Well, he said in his experience, he hasn't talked to anyone else with a school shooting.
He said he's dealt with children who've done very bad things, right?
This is like bad, though. I mean, this is
Yeah.
like,
Well, we're going to move on anyway. You guys can watch the video and decide for yourselves, okay?
I have nothing further, thank you.
Okay, props.
it's fair to say that every parent reacts differently when confronted with news about their child.
Yes,
And you don't know Jennifer and James Crumbley, correct?
no, I do not.
And prior to this day, you had never met Ethan Crumbley?
No,
So whether their reaction was even normal for how they normally react, you wouldn't even know that.
correct.
I have nothing further.
Redirect.
Just briefly.
Your Honor, I do have one question, if I could just have a moment. Okay, there's one, it's listed with them. I was just asking about an exhibit, Your Honor, that's listed through Sergeant Brian, but it's coming in through a different.
Okay,
Okay. I'm just trying to make sure I'm keeping track.
okay, yeah.
Thank you.
That was only, the video was and the transcript were the only ones.
Correct.
Okay.
In your experience, you ever deal with a parent in this situation who was scrolling through her phone during this interview?
No,
Nothing further.
Your Honor, I object as to relevance, and she's giving the phone to him. I at least asked for recross.
You can ask him another question if you want. Go ahead.
While Mrs. Crumbley is showing you things from her phone during the interview, correct?
she showed me the picture, yes, ma'am.
And she's trying to zoom in on the picture, and the thing won't zoom in, correct?
Correct.
And she's sitting there scrolling, looking for it on other messages and threads. Or
I don't know.
you don't know?
I don't
Okay,
know.
fair enough. Thank you.
Nothing
Okay, you can step down and
Thank
make
you, Your Honor.
sense. Thank you. Who's the next witness?
further. Judge, may we approach?
There are a large number of exhibits that we want to tailor for you, pictures of the scene and things like that. So rather than have you hang out while we do that, I'm going to release you for the day, all right? And have you come at 8:30 in the morning. All right, I'm going to get started at 8:30 in the morning. During this trial, do not read, listen to, or watch any news reports about the case. Under the law, the evidence you are to consider to decide the case must meet certain standards. For example, witnesses must swear to tell the truth, and the lawyers must be able to cross-examine them. Because news reports do not have to meet these standards, they can give you incorrect or misleading information that might unfairly favor one side. So to be fair to both sides, you must follow this instruction. Do not go on social media. Do not go on Facebook or post or read Facebook. Do not do research. Do not discuss the case with anyone. Don't read a newspaper. Don't watch the news. Any questions about that? We're making a good time, but I don't. You guys hang. It's easier for us to go through the exhibits while you're driving home. It'll be quicker this way. Okay. Any questions about the schedule? All right. Okay. I'll see you tomorrow at 8:30. Okay.
All rise for the jury.
You may be seated. Okay, so tell me what we're doing now. You guys are spending time together, and
First, Judge, what I'd like to do is go through our exhibits that we have with Detective Stoic. Those are the exhibits that counsel objects to. What I want to do is remove the specific exhibits that we have agreed upon,
okay,
and then we can come back in here and the court can rule upon the balance.
okay.
So maybe it'll take 15 or 20 minutes for me to do that. We just went through it at
Okay,
lunch.
so you're going to let me know.
Yes, that's agreeable to the court.
That's fine. I was trying to figure out at the bench what the exact process is that you were asking about. So you are going to spend some time with Ms. Smith, and you're going to let me know.
Yes.
Okay.
First, I'm going to fix the exhibit list,
Okay,
and then
sure.
I'll get a copy to Ms. Smith as well as the court, and then I'll speak with Ms. Smith.
Okay.
And if we don't have a complete agreement, we'll let the court know, and then the court can make the eventual ruling.
Is that's today?
Yes, Judge. If the court is able to stay.
I'll stay as full forever. I just have to sweet talk the deputies into staying with me. So.
It shouldn't take terribly long.
Okay. All right. So you're gonna let me know.
Yes, Judge.
Is it okay if we just sit here, Your Honor?
It is okay if you sit here. If you want her to stay with you.
Can she stay with me?
Yeah, she can. Yeah. Yeah, they're going through exhibits. So, okay, so you're gonna let me know.
Yes, Judge.
Please keep in mind that are you guys still gonna film or? Yeah, I don't know, because I want to make sure I don't get complaints about media picking up privileged communication or.
I
I think that's up to you, Your
That's a
Honor.
question.
It is.
It's your courtroom, man.
I like this guy. Why don't we not record while they're going through exhibits, and then when we go back to on the record and make rulings about it, because she's going to talk to her client, and that's okay. All right, good.
All right, so it looks like they're going to be going through some exhibits. So it looks like this case is done for today for all purposes of that. I may come back on. I'll keep an eye on this to see what goes on. I don't know how long this will take, but I'm not sure that it's anything we need to necessarily worry about because obviously we're trying to watch what's getting presented to the jury. I'm going to probably end the broadcast here for today's court because the jury's dismissed. It'll be back in the morning, and I guess they got to go through these exhibits. So some interesting information coming out today. I mean, I think today was a good day for the defense. I don't think it was a great day for the state. However, I think the demeanor of the defendant when she was around the police kind of explains why they probably went after her, because I mean, she doesn't seem like somebody. I mean, she really has just a bad attitude about this whole thing, and just a very I don't know. It was not what I would have expected if my child would have been accused of that. I mean, essentially, they had to have known that was probably the last time they'd see their son. Most parents would ask, "Hey, can I have a few minutes with my child and talk to him?" And they were just, and she was just like, you know, yeah, done. I'm out. Walks out of the room, and that was interesting situation when we saw that at the police station. So again, this case comes down to the issue related to whether or not the jury believes she was negligent in her actions and behavior in relationship to um, prior to the crime. So all of this stuff coming in after the fact, I don't really know how it contributes to that, except to turn the jury against her, because the state in this case, I think that's the strategy, is they want to make this jury mad that this happened, mad at the defendant's behavior, make her look like she's someone who's an uncaring parent, and then they want to lock her up for essentially and the thing is, I'm not disagreeing with any of these points, and maybe she could have done things differently, or maybe she wasn't the most attentive parent. I don't know. I wasn't there to see it, but this idea that we're going to apply involuntary manslaughter to this and say that her bad parenting contributed to this. I mean, that's the story all of us would love to hear on a um, on a uh, you know when you're watching a news channel or commenting on a news channel and you want to get outraged over something, but it's hardly enough to stretch to manslaughter. And here we go. I wanted to show this again. Again, the state is alleging in this case, and I know this only because I read the appeal, all the appellate information, which I haven't gone over yet, but I have the cases, which helps better understand the theory of this case and what the state's trying to prove. But their allegation is uh, essentially that the negligence in this case rose to the level of ordinary negligence. Gross negligence deals with manslaughter of a vehicle, a motor vehicle. Ordinary negligence is essentially an element of negligent homicide, but normally it would be applied to the principal person involved in this homicide. In other words, somebody who was, pulled the trigger or did something, operated a piece of machinery, whatever. They were involved in the actual crime itself. In this case, it's a novel approach that could lead to, technically speaking, if this case were to proceed forward and come to a guilty verdict, and survive appeal, it opens up the potential here that you could start to apply this law to places like the bar that serves a drunk, or the manufacturer of the gun, the manufacturer of the gun company. So it's this it's really a slippery slope here of that we're getting into when we talk about this. But the place here that they're coming into is ordinary negligence means not taking responsible care under the circumstances as they were at the time. So the circumstances they're alleging is that she should have known he's drawing she knows he has access to a gun, potentially. She knows he knows how to use a gun. He's drawing photos about, wanting to perform a school shooting. She's aware that he's had problems, and all of that's present, or should have been present, in the state's mind at that moment when she walks into the school. And then if someone does something that is usually dangerous, something that a sensible person would know could hurt someone, that is ordinary negligence. So the ordinary negligence in this case, according to the documentation I've seen, and that's what they're essentially coming to prove here, is it wasn't anything related to the gun. That's going to be on the father leaving the gun out. His is a totally different case. It's why they ended up separating the cases, because the theories are almost two separate ways, and they don't want the gun information to get in that's going in on the father coming in and them looking like they're a couple. It's why the defense separated the two, or asked to separate the two. The state would love to have had it together, because then it would kind of all be blurred back in that jury room. But it says if someone does something that is usually dangerous, something that a sensible person would know could hurt someone, that is ordinary negligence. So In this case, that act is she's standing in the school and she lets him go back to school. That's it. They're saying she had the opportunity to pull him out of the school, take him down and get him counseling, or pull him out of school until he was ready, pull him out of school, do something, right? Do something to get him help at that moment. But the question is, but you can't just say, well, she didn't get him help. She had to have some sort of idea that, hey, this kid is an imminent threat to people. He's going to go. He's got access to a gun, but she didn't know he had a gun. There was no knowledge at the moment, and of course everything she's doing that day, regardless of whether you liked her demeanor or not, or her attitude, she's racing down to the school. As the counselor said, normally you don't see two parents, so obviously the dad and him were very close. I see this as parents who maybe just were too close to the situation, and as sometimes parents do, makes excuses for their kids. Sometimes the parents, and this to me is the issue I have with this case. The professional there, the trained professional in the school, he says, uh, you know, he says you're okay to go to class. I mean, this idea here that we're going to sit here and say a parent who's close to their child should be judging their child as if they're the next Hannibal Lecter is crazy. Parents don't do that. I mean, I'm a parent of 4 kids, and 3 and 1 on the way. But I've dealt with a multitude of things, and sometimes I'm not the best judge of my kid. Sometimes I need outside. Now, I would have handled this completely different, and absolutely, I think um, you know, especially at the police station I'm talking about. Now, leading up to it, if I had a child saying that, yeah, I would say I probably would do things different. I would probably be absolutely, I would think getting him into counseling. But can I say that? Do I know? I mean, this father was extremely close with his son. So I don't think if he believed his son, when he's sobbing in the police station, is going to believe, oh, my son's going to go shoot up the school, that he wouldn't have thrown himself in front of that bullet and said, I'm going to do something to stop it. He absolutely would have. I mean, this is an offensive case by the state of Michigan in the theory that they're bringing it, and I think it's terrible. I mean, I really do, and that's why the defense attorney's standing up there. That's why she's saying, you're essentially victimizing 12 people, making them watch. Look, they took a plea with the young man that did this. He's going away for life. He's lost the right to ever walk the streets and be free, and there's obviously, that's a discussion for another day on whether or not that should have been life. Many people say absolutely. It's not so conclusive because there is a wealth of studies and information that supports the idea that his decision making at the age of 15 is not uh you know is not going to be the same decisions he'd make at 30. He's still redeemable. But like I said, that has no basis here in this conversation about the parents. So I won't go down that road. But the point is, he's punished. The state shouldn't be trying to try his case and put on all this inflammatory information because they're scared that if they don't have this jury so hopped up and angry that they're going to feel bad for the parents. So what they're trying to do is they're trying to get them so upset and outraged at the suffering of the students and the staff that they're going to be so mad they want to hold these parents accountable because it was their kid that did this. But to me, that's offensive. That's offensive. That's an offensive approach, and that's why that defense attorney, what she's doing. And when I first saw her, I'm thinking, man, what the heck? But now, as I've looked into this case and watched 2 full days of this, now we're into the third. And learned a little bit about her background. I understand what she's doing because you know what? She has every right to be completely outraged by what's happening in this case because the way they're trying this case is not fair. And the judges allowed it because I think it's a novel, new use of the manslaughter law, and the state appeals court opened up the door and let them do it. And here we are. But the bottom line is that jury, when they're back there, this is the rule they're going to have to look at. And if the defendant did not do what a sensible person would have done under the circumstances, then that is ordinary negligence. And here's the issue I see with that. When you have a trained counselor in the room with the parent, and the trained counselor, yes, they're not aware of the gun, but that trained counselor may not have been aware that there was a firearm, available. But listen, think about this. This student is searching for bullets in class. He's writing about a school shooting on his paper. At a very minimum, the school resource officer should have been in there searching his book bag. There's probable cause, and I do believe you are allowed to search book bags. It's my understanding lockers and book bags are absolutely allowed to be searched on school premises if there's in the calls and standards not even as high as it is for anyone outside the school because you're on private property of the school, or I guess you're on government property or however you want to view it, but municipal property, whatever. But the point is, they had every right to search the book bag, and they didn't do this. There should be a whole lot of other defendants in this room because if we're going to go down this road, but I don't think we should go down this road. I think that this is a tremendous tragedy. I think that the schools themselves need to set up that when somebody is doing these things, we don't make assumptions and we provide modes of support. I think there should be a way that he should have been there should have been a way for the school that when he is, and this is my opinion, this is a solution that I think would be something that could be done. If you've got a kid who's drawing drawings of guns, he's saying he's depressed, he's talking to the counselor, that school counselor should be able to send him over to the local hospital, to the wing of whatever, and he should have a 48-hour commitment where he gets to see immediately a mental health professional. They do a workup on him. They find out what's going on. And then the parents have to come in. And then the parents got to take responsibility for that situation at that moment. And they got to meet with mental health professionals. And then on top of that, now when he comes out, the school officials get to review this and say, does he come back, to make sure we don't have some mentally unstable person that's going to come in and shoot the school up. I think at that point, you bring the police in and you say, well, okay, this kid's, he's saying he's going to do a school shooting. What access to weapons does he have? What are we looking at here? But there's plenty that can be done in this instance that doesn't involve this, because this is just a situation of we didn't have the tools in place to try to prevent this, and now we want to take a legal solution to lock up the parents, so somehow that makes us feel better about the situation, but it does not, because it's a dangerous situation. Not to mention, I don't think this survives appeal when you look at the vagueness of again, unfortunately, they could not appeal yet, the issue of how they applied this law or what they argued to the jury, because you've got to have the state do that first. They've got to make their argument to the jury. They've got to put forth what it is, what the evidence is going to show. And then at that point, if their argument is that that the sole purpose, the sole allegation of recklessness in this case is ordinary negligence, then at that point, what's your theory of ordinary negligence? And if their theory is what it sounds like it is, which is, well, this parent didn't care enough, well, what's the level of care? I mean, you've got to define that. It's undefinable. So I could see this getting reversed, maybe. I don't know, but I think there's definitely great appealable issues. But obviously, the idea is not to get there for her, because she doesn't want to sit in prison waiting for this, because she's got multiple manslaughter charges stacked. She's facing 15 years on one, but each one's its own separate one. And she's got the potential. I think it's 5 manslaughter charges. So if you're doing the math on that, that's like 75 years in prison. I mean, that's the rest of her life, essentially. So it's pretty serious business. But let me check and see if there's any movement in the courtroom before we call this. I don't think there is. Nope. Looks like they even ended the stream. So it's definitely over with, it looks like. I'm going in to see. Yeah, no. Doesn't look like So yeah, it looks like they've pretty much ended the stream. It looks like on the stream I was on. So that's where we're staying. But anyways, we'll be back tomorrow. I'm going to be back a little bit later here with the Murdoch case. We're going to have to run that because that there were some big things going on with that while I was getting caught up with this. But I wanted to make sure we got it caught up. We got bag search for energy drink. Yeah, absolutely. Yes, when I was there, man. This is that's what I'm saying. Like, I mean, my kids' school, I know, like they're on top of it over there. I mean, and they, you know, somebody's making a threat or something. There was at my son's school, they sent out a big email because they found a student who'd written down like some sort of hit list or something. And the kid was taken out of school. Now, obviously, you might say, well, that's a hit list, but he's writing on a piece of paper, I'm going to do a school shooting. And you're not going to let him stay in school? And then you're going to sit here and say, well, I advised the parent that I thought it would be nice because I mischaracterized it as a suicide cry for help. I mean, what the hell? Like that? Yeah, okay. I mean, that's ridiculous. In terms of when you look at the situation, I mean, how do you mischaracterize that? I mean, when you see that sheet, to me, that tells me this kid, the school. But again, if you're walking in, you don't want your kid in trouble. You're wanting to think the best of your child, and you're walking in and you're trying to understand it. And when the school isn't saying this is what it is, but I also know for a fact, now my child was involved in nothing like this, but there was a time that I was attempting. He's a type 1 diabetic, and I had to get him. He wasn't taking his insulin shots, so they were asking us to get him involved in some counseling for that. And I tried to call to get it done, and it took us. Now, again, it's not obviously as exigent as saying, well, we have somebody who's talking about a school shooting, but it took us a couple of weeks before we could get in and see a professional. We were told in our area it's very difficult to get a child related because there's a shortage of people, at least in my area, who do child counseling. Obviously, you could go to the ER. My wife works in mental health as a nurse in the ER, and she says, hey, she has kids all the time in her ER that are sitting there that are staying there while they're waiting for placement in a hospital because there's limited resources. So this idea, now maybe Michigan's different, but this idea that you could just take him out of school and in an hour, especially in 2021 when there was provisions for COVID, I mean, it's going to be difficult to make that happen. So, I mean, this whole thing is crazy. But I mean, hopefully there are parents on that jury and there are reasonable thinking people on that jury, and we can and nobody's going to allow for this thing to not be at least have some common sense and rational thinking applied to it. And then on top of that, hopefully somebody takes the law, because this is the instructions, what I'm putting in front of you, the reason why, and this is how you should watch a case. If you're watching a case, go look up the jury instructions. Every single state has it. You can look up the jury instructions just for the state you're watching it in, and you're going to see all the instructions that the juries will have. Now, the thing you won't know is necessarily some instructions may apply, some may not. Then if you want to go a step further, in this case, we had a reference tool because of the fact that there was an appellate issue where they had appealed early. So it was able to help me understand a little bit where I needed to look. But even if you didn't, you could just read down this entire thing and kind of start to kind of understand the different elements of the crime. And then in the case, if you listen to the opening statements, you can kind of start to get a picture. And again, we don't have to be lawyers to do this, because this is what a common everyday folk is going to look at. So if we're looking at this, we have to say, if we're sitting on this jury, which is what we do when we watch these cases, if we were sitting on this jury, how would we apply the law we see on that document? But this is if you're watching a trial without doing this, without looking at this stuff, you're going to you're robbing yourself of being able to really analyze it and see, because believe it or not, it's not really as simple as did she do it or not. And in this case, there is some complexity to it. But every case, there's elements of the crime. It's got to be proven beyond a reasonable doubt that this individual did what the state is alleging, based on the elements in the jury instruction. That's the best place to go, because that's what they're going to be. That's what they're going to have back in the jury room, and that's what they're going to deliberate on, and go from there. So, anyways, guys, I will be back, like I said, in a little bit with the Murdoch coverage. Everybody that's in chat, everybody that's watching, I appreciate you. Thank you for coming in, Skylar. Thank you for your input. I enjoy hearing from everybody, because, again, remember, we're all citizens. We're all going to could serve on a jury. I've already served on a jury in my lifetime. I'll probably do it again. So will you. And that's who's sitting in that box. So you don't have to have any type of special credentials or anything to analyze a case, because ultimately, when you get past all the fancy degrees and all the schooling that a lawyer goes through, at the end of the day, they're speaking to 12 ordinary people who have no requirement of any educational background or anything like that. So that qualifies all of us to watch, all of us to give our input. And I'm sure the lawyers watch when there's national cases, because, again, how it's coming across to us is significant, because that's exactly who they're speaking to every day in that jury box. Anyways, guys, thanks for watching. And until we talk again, let justice prevail, and I'll talk to you soon.